Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today, cross-border tech deals, safeguarding innovation without slowing the business. I'm your host, Julian DeBell. I'm a partner in Mayor Brown's technology and IP transactions practice. I'm joined today by my colleagues Aisha Hussain, Rohith George, and Joe Pinnell. Aisha counsels startups and multinational companies on national security and international trade with a focus on export controls on the Information and Communications Technology and Services Program, ICTS, and economic sanctions. Rohith and Joe are both members of Mayor Brown's technology and IP transactions practice, and they advise clients on digital infrastructure, digital transformation, and outsource services transactions, including with respect to generative, predictive, and agentic AI. So let's get into it, Joe, and just to orient our audience, what is a cross-border tech deal?
Thanks, Julian. So for our purposes, we're talking about any deal where a company in the U.S. partners with another company to develop new IP or technology outside of the U.S. So this could be a software applications development and maintenance outsourcing deal in India, which a lot of the people listening to this podcast are probably familiar with. It could also be a co-development deal to design and manufacture a physical product in China, any deal where IP is being developed overseas on your company's behalf.
Okay, so let's say you're an in-house counsel, maybe someone listening to the podcast, and your business client approaches you about one of these cross-border tech deals. What do you do first?
So this is often a stage before outside counsel are involved. So it's a real opportunity for in-house counsel to add value. I'd start by just asking some really basic key questions. So first, what's the logic and purpose of the deal? Who's the partner? Where are they located? Have we done any due diligence on them? What's their financial wherewithal? Do they have IP assignment agreements in place with their employees? Is there any outstanding litigation against them? And if there aren't good answers to these questions, you'll need to work with your business clients to answer them before you jump in and waste a lot of time on a contract.
Aisha, from your perspective in the national security and export controls world, what types of questions would you be asking?
So I would really be starting with the item that's involved in the transaction and trying to understand whether it's regulated under U.S. export control laws. Export controls apply to both defense articles, or these are things that go boom, and dual use items. And these are items that can have a civilian application or a military purpose. The most sensitive of these items are listed out on U.S. government lists. They cover commodities, physical things, software, and technology. And technology really is know-how or information related to a physical thing, say shortened definition. These lists include a wide variety of items: gas turbine engines, semiconductors, life jackets. So there is a wide variety there. And so it's important to involve your export controls lawyers to understand what the transaction exactly encompasses. And then I would determine whether there's a license required. So if we run through a quick example, if the transaction involves semiconductors, the semiconductors may be controlled. They might be on these U.S. government lists. The software for the development, production, or use of the semiconductor could be controlled. And then the know-how on how to develop the semiconductor could be controlled. So yeah, I would go through that analysis. Then I would look at, okay, who am I working with on the other end? Who am I working with? Who's going to get the items? And are they restricted persons? Are they in jurisdictions of concern? And from there, you have to determine, is a license required? And if there is no license required, that's great. But I would also try to really carefully look at who is involved in the transaction and whether I trust the other side. Because ultimately, if you're dealing with cutting edge IP, you want to deal with a trusted partner. You want to deal with somebody that, if you're sharing sensitive technology with them, you want to make sure that they don't take it. And contractual clauses are only going to protect you so much.
Great. All right, Rohith. Assuming that the business has good answers to the questions that Joe and Aisha have framed, what's the first key risk that you need to be thinking about as you start papering the arrangement?
Sure. I think the biggest and perhaps most obvious risk from a legal perspective is ambiguity about who owns what IP once you're entering into this relationship. So, for example, if a U.S. firm outsources development of a machine learning algorithm to an overseas partner, who owns a trained model, who owns the training data, and if the contract doesn't explicitly say, default rules in many jurisdictions would give ownership to the creator, which is often the developer or your partner. And while that isn't, unique to cross-border deals here, without clear contractual allocation of ownership, it may be difficult to, enforce your rights in another country if it ever becomes necessary to do so. So, to avoid this, you'll need to clearly define the key buckets of IP, define who owns each bucket. First you have your pre-existing or background IP, and most commonly each party retains ownership of what they bring into the deal. The other major bucket would be for foreground IP or for developed IP, and within that category, you can have different sub buckets for truly greenfield IP that's wholly new versus derivative works of either party's background IP. At the end of the day, for the customer, often you'll start from the position that you own all developed IP, unless it's a derivative work of the supplier's background IP, and in that case, you get a broad license that gives you rights to continue to use even after the supplier's gone. But regardless, whatever the deal is, it's important to define these different buckets clearly, rights of each party with respect to each bucket, in order to really be able to enforce these things across borders.
Okay, well, that all makes sense. But what do you say when your business client says, "Hey, this is a partnership. Why don't we just jointly own all of the developed IP?"
Yeah, I mean, joint ownership arrangements are complicated. They do create some problems in practice under both U.S. law and in other jurisdictions. A few of them. First, neither joint owner will be able to assign its rights in the jointly owned IP to a third party, which can create a hold up risk. And if your company wants to sell the IP later, whether that's in connection with M&A activity or otherwise. And that, in turn, naturally muddles valuation because investors or acquirers will discount assets that they cannot ultimately control. And then, each joint owner typically can freely grant sublicenses to the IP to third parties, which, in particular cases may be less control than you want. And then another issue is that joint owners may have to account for profits to each other, and this can vary depending on the jurisdiction. And that's at minimum an administrative burden, and it could lead to disputes over, incorrect calculations, underreporting, and so on. And then finally, maybe perhaps most importantly, the arrangement complicates enforcement as well. So most courts will not allow a single co-owner to sue infringers without joining all the others. So a reluctant partner could block timely relief that you need. But all of these things can be contracted around. It just adds a lot of complexity to the equation. And so, other than in rare cases where it does make sense as a contracting structure, it's typically not an optimal or practical solution.
Okay, so let's say you're not going with that approach. You're going with a more clear cut, one party owns the IP and the other provides a license to the other party approach. Joe, looking at that license piece, are there any risks to be aware of in crafting that license?
Sure. So the main risk is granting more license rights than you intended to. So assuming that you're the owner or licensor, you should be specific about the territory, duration, and scope of your license grant. If the supplier is only allowed to use your IP to deliver services to you during the term from India and the United States, you need to spell that out clearly. Also, some jurisdictions will imply certain IP rights unless they're expressly disclaimed, so it won't have a clause reserving all IP rights that you haven't expressly granted.
All right, so then setting IP per se aside, cross-border collaborations often require sharing sensitive code or know-how just to get the work done. Joe, how can companies protect confidentiality of those sensitive code bases and know-how elements, the trade secrets, really, when working with overseas partners?
Yeah, if you're giving access to your crown jewels of IP or trade secrets, et cetera, a standard NDA may not be sufficient. And the effectiveness of confidentiality protections can vary widely by the jurisdiction you're in. So it's a good idea to take a belt and suspenders approach. So what does that mean? So first, draft specific, robust confidentiality clauses. Have specific definitions of confidential information and trade secrets that have listed out categories to eliminate ambiguity. Spell out all the buzzwords, source code, technical designs, customer lists, business plans, etc. Also, it's really important to specify the permitted uses of the information and then prohibit any other use of the confidential information. Second, make sure there are affirmative security obligations. For example, you could require that source code be kept on a secure server on your networks back in the United States, and that only a short list of named personnel will have access to those servers. Then finally, make sure there are strong remedies and exit rights. If there's a breach, you should have express rights to obtain equitable relief, indemnification, and be able to exercise bright line termination rights. And like any other agreement, you'll want obligations to return or destroy your IP and other confidential information at the end of the term or at any time upon your request.
Right. So it's interesting that it's not just about the confidentiality provisions per se and the commitments, to how to handle information, but it's also about like security protocols, you said. And I'm intrigued, Rohit, is there more along those lines that companies can do to mitigate the risk of information leakage?
There are, but obviously they're going to be highly dependent on the nature of your cross-border collaboration. So, as Joe mentioned, you may want to limit, regardless of what the contract says, you may want to limit any sharing of sensitive code to a real need-to-know basis. You might set it up so that the partner can, for example, only access compiled code or APIs rather than source code, if that's feasible. In general, I think you're looking for technical limitations on what can be copied or actually retained. Right. And then beyond that, I think the goal is to train and monitor. So you want both your team and the partner's team to be aware of their confidentiality duties. And the thing is that sometimes breaches aren't necessarily malicious, but due to ignorance or lax practices. So, companies could conduct joint training or at least provide written guidelines. And then you don't just ultimately trust, you monitor compliance. So that could be periodic audits or check-ins to kind of confirm that the partner is following the security protocols and the security requirements. So the core takeaway here is that, you shouldn't assume that everyone treats confidential information the same way. In cross-border deals, you want to make your expectations explicit, you want to make them enforceable, you want to make them auditable.
Okay, Aisha, again, from an export control perspective, what are the considerations there around sharing sensitive code or know-how?
So sensitive code, which I am assuming it includes source code and object code and know-how, are all could be controlled under the export control regulations, the U.S. export control regulations. And sharing these items overseas or with a foreign person can trigger U.S. legal requirements. So as a first step, I would bring in your trade counsel, review the code and the know-how being shared, and determine whether a license is required. And so, for example, I like using examples in the export controls context because it can help bring the issues alive. So take source code, for example. You would want to know if it is regulated source code. Is it on a U.S. list? Is it connected to an item on a U.S. list? Then you want to understand where it's going outside of the US and how it's going. Is it an email? Is it going to sit on a server? Is it going to be on a US server? And then who will have access to it? And the access question is a very important question because in the US export regulations, we have what's called deemed exports. So if a foreign person sees controlled source code, then the government treats it as if the source code has been exported to that foreign person's country. And so depending on the answers to those questions, you may need to apply for a license before you commence the transaction entirely. And you would need to go through the same analysis for object code, although deemed exports are not an issue for object code, but the actual export of controlled object code may be an issue. Know-how can also be controlled, and you go through the same sort of analysis. Know-how, again, is technology that is information or knowledge that can be used to make, develop, or make or develop an item. It's not the finished product itself. So this could include blueprints, technical manuals, or drawings.
All right. So it's a potentially pretty broad swath of types of information that could be covered. But so let's say you've done your analysis and you've established that your deal is going to involve sharing of know-how or code that falls under one of the U.S. export control regimes. And you've got set things in motion to get a license if you need it. You're establishing internal controls. What about with respect to, your cross-deal partners themselves? How can companies ensure ensure compliance as an aspect of entering into these cross-border relationships?
So I think you need to really look at your contract clauses. You need to make sure that the contract aligns with your expectations. There's representations and warranties in the contract that each party will comply with applicable export controls and sanctions laws. And if you are, and you can ask the counterparty, how are you going to do it? What are you going to be putting in place? And have them be very particular. I think also what you can do with very sensitive items and code, and I think Rohit or Joe may have mentioned this, but making sure that those items stay on US servers. And then you can implement access controls. You can set up clean teams and segregate access for sensitive items. So for example, if there are certain nationals of countries that cannot have access, you might want to just keep those items on US servers and implement access controls to make sure that's in place. And then I guess lastly, going back to the contractual issues, I would also include a right to terminate or suspend the contract, if there is a violation of export control laws or sanctions laws.
Okay, great. Well, Joe, you mentioned earlier in connection with this, the issue of protecting trade secrets that, one approach would be to make sure you can seek equitable relief to prevent misuse of trade secrets. That kind of gets us to another issue, which is the enforceability of these cross-border agreements. And my understanding is, and Rohit, you kind of touched on this earlier, is that enforcing IP rights and resolving disputes can be difficult internationally. What strategies would you recommend to companies if they want to actually enforce rights across borders?
Yeah, I mean, that's right, Julian. So enforcement can be tricky because you can, sometimes you're not on your home turf, and an IP right ultimately is only as good as your actual practical ability to assert it. So, and when your counterparty or your assets are abroad, there are some legal and logistical hurdles. So we'd recommend obviously planning for this ahead of time before you sign the contract, probably before you even decide whether to do the deal. So, first you want to choose the right dispute resolution mechanism, and perhaps, that may be the single most important decision is how these are going to be resolved. So many companies at the end of the day favor international arbitration for cross-border IP disputes. And that's because an arbitration award under the New York Convention, the 1958 New York Convention. An arbitration award is in fact enforceable in over 170 countries, and there are limited grounds for refusals. So in contrast, a court judgment from one country, so let's say a U.S. court judgment, it's often not automatically recognized or easily enforced in another country, absent a treaty between those two countries. So, consider an arbitration clause, seek the arbitration in a neutral country, use well-known rules, ICC, ICDR, so on. And then the panel, it should ultimately and ideally include arbitrators that have tech and IP expertise so they can decide these things reasonably and fairly. So, and then if for some reason, you're completely opposed to international arbitration, I think you want to find jurisdiction, governing law forum that has a track record for respecting IP contracts, granting remedies. If you can't get your home jurisdictions, sometimes you opt for exclusive jurisdiction in a more reliable third country like Singapore or England, if that works for both sides. But keep in mind, though, still, the issue still exists, which is enforcement of a foreign judgment. It can still be tricky back in the partner's country unless there's a treaty between those two countries. So that is why arbitration is typically favored. But I think those are the steps you would take to try to structure this in a way that works.
So, Joe, any additional thoughts on the enforceability question?
Yeah, so consistent with everything Rohit just said, if your counterparty's really insisting on using local law and courts in their home country, you'll want to do your homework on that. So how have foreign companies fared in enforcing their IP or contract rights there? Are the courts biased against foreign plaintiffs? Do courts drag out cases for years, including with appeals? Do courts require trade secrets to be registered or shown to have substantial economic value before they grant a plaintiff relief? And if you obtain knowledge and answers to those questions, it might help you negotiate harder for different governing law and arbitration as the dispute resolution mechanism for all the reasons that Rohit talked about. And finally, and this ties back to earlier points, but the more clearly you've defined your IP rights in the contract, the easier enforcement will be. If your contract is ambiguous, it's harder for an arbitrator to rule in your favor.
Great, makes sense. Aisha, I wanted to circle back to another export control topic or export control adjacent topic. This is sort of the flip side of export controls, where a country is trying to restrict the transfer of technology out of their country, but there's also the issue of forced technology transfer. Can you talk a little bit about what that means?
Forced technologies transfer, it refers to situations where companies feel compelled to hand over valuable technology or IP to gain market access or regulatory approval abroad. Sometimes it's an official requirement, sometimes it's an unspoken requirement. Either way, it's a major concern for cross-border deals. China is probably the most cited example. While China has formally outlawed forced tech transfer in laws, in practice, foreign firms often feel pressured to share IP as a price of doing business. And what companies really need to know is, what kind of jurisdiction are they going to be operating in, and recognize the risk factors. And some red flags include local laws requiring local ownership of certain IP, requirements to disclose source code for certification. And once you spot these, you can employ several strategies. You can limit the transfer. Rohit and Joe, I think, already mentioned, do not transfer the crown jewels unless absolutely necessary. If the deal can be structured so that sensitive source code or algorithms stay on your servers and only outputs or interfaces are shared, I would do that. And if you share some source code, maybe share only compiled code or an API access, or through an API access.
Great. Well, y'all have given a lot of food for thought today for folks entering into these cross-border partnerships. Any final additional thoughts?
Yeah, so we covered a lot of ground in terms of contractual protections, but you'll also want to write in clauses that directly address tech transfer concerns. So reverse engineering restrictions, no subcontracting without approvals, so the partner can't quietly pass your tech along to another entity that's acting as a subcontractor locally. bright line termination rights for suspected infringement or other changing circumstances. For example, if a partner's ownership changes and a competitor or state actor becomes involved who you'd never have done the contract with in the first place, you might want the right to terminate the license immediately.
Yeah, and I just add, I know this is a bit of a challenging, confusing macro climate for cross-border deals of any kind, and we've talked about a lot of the risks associated with these kinds of deals, but we've been doing cross-border technology deals for, decades now, and despite the current climate, we're not really seeing much of a slowdown on the technology services front. So these deals will keep hitting your desk, and if there are more risks to consider now, there are still lots of ways to mitigate those risks, and our job as lawyers is to find the path through that ultimately does that. So hopefully our discussion today highlighted some of those points, some of those paths, and we're obviously always just a phone call away. Happy to assist.
Great. Well, thank you, Rohit and Joe and Aisha. As always, we really appreciate your insights. Listeners, if you have any questions about today's episode or an idea for an episode you'd like to hear about, anything related to technology and IP transactions and the law, please email us at techtransactions@mayerbrown.com. And thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.